It is case number 108684, State of Kansas v. Hernandez.
May it please the court, I'm Janine Cox, Deputy Appellate Defender representing Mr. Hernandez today. I'd like to reserve 3 minutes for rebuttal, Your Honor.
3 minutes is granted.
I know the court's familiar with the facts of the case. Mr. Hernandez was convicted by a jury of 1 count of rape, 2 counts of ag-crim sodomy, 2 counts of criminal threat, 1 of aggravated burglary, and 1 count of domestic battery. He was sentenced by the trial court. Mr. Hernandez had no criminal history to 330 months. Court of Appeals affirmed the convictions. There was a motion to correct a legal sentence at one point, and his sentence was corrected to 321 months. Mr. Hernandez filed a petition pursuant to 60-1507, raised a claim of ineffective assistance of counsel. District Court denied the petition. Court of Appeals affirmed that denial, and this court denied a petition for review. In August of 2011, Mr. Hernandez filed a motion pursuant to KSA 2512 seeking forensic DNA testing. The District Court denied the motion. The Court of Appeals affirmed the denial, and this court granted review. That's where we are. The district court's denial of the testing, in our view, failed to recognize that 2512 is an expansive and has been viewed as an expansive statutory provision. The statute provides that the court shall order upon a determination that testing may produce non-cumulative exculpatory evidence.
What may this evidence produce? What is the evidence that this could produce or may produce? What's the non-cumulative exculpatory evidence specifically? I'm having trouble seeing where it is. In
this case, the testimony at trial, Mr. Hernandez's position always was this did not happen. This did not happen. If you recall the facts of the case, it actually came...
But if his DNA is either on the bedding, the sheets, or not, that he occupied that bed, didn't he, at the time? So if it's there or not, what is that going to show us? In her
bed, he didn't occupy that bed. Obviously, his bed was the other bed. If she says it happened here, if there's no DNA evidence, then that impeaches her testimony that it happened. At least it's some relevant evidence to show that.
I don't
know. And that's the test. It doesn't have to be an exonerating.
No, I understand that, but I'm just trying to. How does that fit with the defense here?
Well, that it didn't happen. So if it didn't happen and there's no evidence on there, then that at least goes to his theory that it didn't happen, or his defense that it didn't happen. This is not the same thing as the Smith case, where DNA testing was denied. Mr. Smith, in that case, had already admitted to the fact that there had been sexual activity. He was just arguing that it was consensual sexual activity. So any DNA that was produced in that case would not have been helpful to him. This is not the case. Mr. Hernandez's...
What if a third-party male's? What if an unrelated male's DNA is on CH's bed? Would that be exculpatory evidence?
I'm not sure.
What about the boyfriend? Because we've got evidence that
right.
She, yeah.
That
and we also have a SANE nurse, don't we, that says her examination is consistent with the reporting, and so it would be exculpatory if someone else was involved in the actions that would make it consistent with the...
I would make an argument that could be exculpatory if there was someone else, but I would also make the argument that it can be exculpatory if there's no evidence there. When she has said that the act occurred there, if there's no DNA evidence of my client in her bed, I don't know how that cannot, it may not be exonerating, but I don't know how it cannot be exculpatory.
But isn't the defense argument that there was no evidence produced in the first place to show that he was there other than her testimony? I mean, you're really just trying to corroborate the non-existence of evidence that wasn't produced.
I am trying to corroborate by his theory of defense is that this never happened, and so if we test this, we will see that there's nothing there, and the evidence was, and I'm not sure. I'm trying to remember right now exactly where that evidence came from, but the evidence was that the sheets were the same. They had not been changed since the last.
Can I try to ask the question that was just asked just a little different
Yes.
way? My understanding is that at trial there was no DNA evidence introduced by the state,
That's correct.
one way or another.
No.
And so should that make a difference to a court evaluating one of these motions petitions?
I'm having a hard time understanding why that would make a difference. If there's no evidence, I mean, if I have some evidence that's exculpatory that would fit under this statute, and the statute allows me to have that testing, I can't follow that thread as to why I shouldn't be able to do that, even if the state hadn't presented the DNA evidence.
Well, without the evidence, the defense counsel couldn't stand up in front of the jury and said, she says it happened to
Right.
her bed, the sheets haven't been changed, why isn't there DNA, my client's DNA on there? That argument was not available the way
Right.
it was tried, is that correct?
That's correct.
Now,
That's
I'm
correct.
gonna, if the state, law enforcement had tested the sheets and the comforter and towels or whatever, and the results of that testing was no DNA from defendant on those materials, would that be Brady material that the state would have to turn over to the defense counsel as exculpatory?
Yes, I would
Is
argue
that
yes.
Is that an analog when we're looking at exculpatory, if the state would have been required to turn it over?
I would argue yes, that's true, because if the theory is it happened here, I mean, if she says it happened here, and
Well, let me move you.
Okay.
I'm talking more in terms of the standard.
all right,
Is there a difference in exculpatory for purposes of turning evidence over to the defense versus exculpatory for obtaining DNA testing? Is where I'm headed with that question.
I know where you're headed. I'm not sure there is, but I would be fairly certain if the state had tested and they hadn't turned and it showed nothing and they had not turned it over, that there would be a claim by the defense that Brady had been violated, because that, although not exonerating, that would have been something that counsel could have stood up and argued, just as you said, Justice Johnson. She said this happened, we have the sheets, there's nothing there. So I would argue that yes, I've never thought of it, are they exactly the same? But I think that the argument would be from a defense standpoint is yes, that should have been turned over if in your scenario it had happened that way.
If what she said was true, would that necessarily mean that there would be DNA in the bed?
Ask me again, I'm sorry.
If what she said was true, if her accusation was true, does that mean that there would be DNA and evidence in the bed?
I think there would be a great likelihood that there would be. Do I know for certain, can I say for certain that there would be? I don't think I could say for certain, but if a sexual activity occurred in that bed, there's all kinds of potential for DNA, whether it's
Well, but she said he used a condom, and I mean, so if you take her statement as all the statements she gave is true, would that necessarily mean that there would be DNA in that bed? I think the answer to that is no. it's not necessary, that if what she said was true, there would be DNA, which leads me to ask, so why would the absence of DNA mean she's lying or allow you to even infer that she's lying?
I don't agree with your no statement to begin with, because even if we as reasonable adults all believe that condoms are infallible and therefore there could be no semen in the bed, there can still be other bodily cells, saliva, skin cells, hair cells. So I don't know that we can say that there would, just because there would be no semen, that there would not be some DNA to test. I just don't think that with that kind of activity that there would be nothing there. I could be wrong.
That's a factual question I had. But
Okay.
Is the evidence in the record sufficient to break out whether they look separately for hair or anything like that?
My recollection of the record is that, no, Your Honor, I don't believe
So
they did.
hair could be a possibility.
Hair could be a possibility. Skin cells could be a possibility.
And there
Saliva
was-
can be a possibility.
And there was some evidence of oral contact. So
Yes.
saliva is
That's a possibility. So just because semen might not be there, that doesn't mean that there might not be other biological material there.
They did not use a UV light. And,
I believe that's correct.
and my recollection is that the crime scene investigators said they folded up the sheets to contain anything that was in there, but then didn't go further.
Right.
And so, and my understanding of the CSI's testimony is she didn't dispute the potential that there was DNA material on those. They had just, law enforcement simply didn't seek to find out.
I think that's correct, and I think that it's telling that they preserve the evidence. The state has never said that the evidence isn't available. The evidence is available, has been preserved. So under that scenario, our argument is simply that there's evidence to be tested. It could be exculpatory. It fits under the statute. And I would ask this court to reverse the Court of Appeals decision and remand the case to the district court.
Is there an intermediate step? I mean, are we ready to jump from where we are today to testing? Or does there have to be a step of an examination of this?
I think that there's another step. I think it goes back to the district court, and the district court, and I outlined in the brief the reasons that I thought that the district court erred, and also the Court of Appeals, in terms of dismissing it because there had been no DNA testing or no DNA evidence admitted at trial. And the Court of Appeals opinion, which was relatively short, relied on, again, talked about the Smith case, which is a totally different case and has nothing to do with what happened here. But I think back for a hearing in the district court, a 2512 hearing, the district court still has...
Under the proper legal standard.
Yes, and the district court still has discretion about whether to proceed, but I think that that's the appropriate step rather than just ordering the testing from this court.
And what would happen at that hearing?
Counsel, there was counsel before. I didn't mean to imply that there hadn't been counsel, but the court would again, I guess, entertain the motion for 2512. As Justice Beyer said, under the appropriate legal standard, which I think did not happen here. If you'll recall, and I don't mean to make a big deal of this, but the trial court's general demeanor was these defendants are in prison for lots of years and they just throw stuff against the wall to see if it sticks. Well, I think that a realistic reading of the facts of this case clearly suggests that there's a serious potential for biological material that's been preserved by the state, and that under the rather expansive reading of that statute by this court and the Court of Appeals, that an evidentiary hearing again to look at whether that 2512 statutory provisions have been met. And it really is a fairly simple thing to be met. That there's some evidence, the state has it, it hasn't been tested before.
Would the court at that hearing have to determine that there was in fact biological material on the items that can be tested, and how do you get that proof without?
I don't think so. I don't think you get that proof without the testing.
Yeah.
You don't. I mean, clearly the statute as it's functioned so far has been. Bruner says this, and I think probably Lackey says this too. You don't have to make a specific allegation about, there's a stain in the upper right-hand corner of a bed sheet. You simply have the evidence which the state concedes that it has, and you go forward from there.
But were they addressing that initial threshold of the motion?
I'm sorry.
When Bruner and Lackey say that, are they just addressing the initial threshold of the defendant's burden and bringing the motion forward? Then the state comes back and says, okay, the evidence does exist. Then is there another step for the CSI examiner to look to see if there's even a material to test on the, like, is there hair? Is there anything where it shows DNA? Not that there's a testing to say who the DNA belongs to.
Right? I don't think so. In remembering the cases, and I've been before this court at least 2 times with the Goldsmith case, where we've been up and down the ladder in terms of testing. And if you'll recall, in that case, at one time there were like 34 pieces of evidence that were going to be tested, and there was no indication whether there would definitely be material on there or not. I think the Haddock case is another case where there were some eyeglasses that were tested without any indication that there would necessarily be material there. I think the step is you test. You test, in this case, the bed sheets or the comforter. I don't think that there's an intermediate step where somebody has to delineate whether it's there.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state.
Counsel?
Yes.
Does it make a difference whether the state introduced DNA evidence in the original trial? Should that be some sort of a qualification on the demands of the statute?
I don't believe it's a qualification. I believe it can be a consideration that the district court can look at in addition to all of the evidence that was presented.
But isn't that a consideration for whether whatever evidence is discovered is exculpatory or not, as opposed to whether the evidence should be tested in the first place? That's what I'm getting at.
I don't know. I think it would be. I think it could be a consideration as to whether the evidence should be tested. But again,
Well,
I don't think you look
I'm trying
at
to
that.
understand that. Can you just explain that to me?
I'm not sure I can.
Conceptually, I'm having a hard time with it.
Right. And as I said, in no way do you look at that solely. And I don't think that's what the district court was doing here. But I think, and I will admit that the district court's ruling here, it kind of rambles on and is a bit confusing, but I don't believe that he focused on the fact that there was no DNA presented at trial in making his ruling. I think it was a consideration. And I think when he did refer to there being no DNA. I think he was talking about, he was referring to that as an attempt to explain that this was not a situation where DNA was presented and the defendant disagreed with those results and wanted items retested. I think that's what his discussion was. And then he ultimately found that the items, if items were tested here, they would not produce exculpatory non-cumulative evidence.
So it would be a consideration if this was a retesting situation, but this isn't a retesting situation.
Correct.
Yeah, so it doesn't really seem relevant to the analysis.
And I think that's a determination that the district court can make when looking at everything. And again, everything, the evidence that was introduced, whether there was DNA evidence or not, what the testimony was, what the evidence about the assaults were. Again, I wouldn't say that they can't consider that. I would say that if they're looking at everything, it could be considered.
Counsel, can I just back you up and ask you what strikes me as the basic question or the baseline question, which is, what is DNA testing?
That's
Under the
good.
statute. I mean, the statute uses the phrase DNA testing. What
Right.
is that? Is
Well,
that, and I can think of two possibilities at least. Is that the testing of biological material, or is it the testing for biological material, or is it both?
I believe, and I honestly didn't think about this before the question was posed about, do we even know if there's biological material? And I'll admit, when I first wrote this brief, however long ago it's been, I didn't even think about that threshold question. And I think it is a threshold question because if you look at the statute allows for DNA testing in the cases of those convicted of rape when biological material, and then it goes A, B, C, the things that you need to meet. I think DNA testing is the testing of biological material.
And if that's true, from your position, would it also be true that it would be impossible for a DNA test to reveal the absence of DNA, essentially, or the absence of biological material? And is that what's contemplated? That's what I'm trying to figure out. Is that contemplated by the statute, where the kind of testing the statute contemplates would actually show no biological material? Is that contemplated under the statute?
You know, honestly, I haven't thought of it that way. I mean, I guess if you're testing biological material, I believe necessarily that's going to contain DNA.
I think his question is testing for biological material.
Right. And I think the statute, first you have to know, the way I read it, first you have to know, is there biological material? So I don't, and you may have to ask it again.
So would that be the subject for that first hearing that your opponent is seeking, this question, to answer the question whether in fact any such material exists?
I think quite possibly it could
Okay.
be. I think that is one of the thresholds before the district court that needs to be considered. And here, the information, and I was simply looking, I don't recall the testimony because it has been so long, so I was looking at the state's response to the defendant's petition. And even in that, we lined out the evidence, the physical evidence that had been taken, and it doesn't indicate whether there's biological material or not.
Well, there is an indication because they folded it up. The CSI said we folded it up so that it would encompass or encase any biological, and then they took it into their custody and they kept it. Now, there is some circumstantial evidence that at least the crime scene investigator thought that there was material on that sheet she folded up, and at trial she didn't dispute when the defense counsel indicated that there was a potential for DNA on the collected items. And so I don't know that the state's ever taken the position that specifically the sheets do not contain any biological material. Have you?
No, but that's not the position, and that's not the position I'm taking today. I think it's an assumption. Obviously, they're bed sheets. I would say almost any bed sheets would probably contain some biological material. I think to make the jump then that testing that would result in possible exculpatory evidence, I think that's a pretty big jump to make. And I think that's when you have to look at all of the evidence.
Why is that? Why is that? If those sheets contain biological material from her boyfriend that she indicated that she'd had relations with, but did not have material from the defendant that she also said she had relations with, why wouldn't that be exculpatory for the defendant?
Well, I think you need to look at the fact that there was testimony that the defendant used condoms. There was also information that the last assault.
But did he use? I think there was testimony that he didn't use for the sodomy, the anal sodomy, that he did not use. Correct.
Correct.
Okay, so
Correct.
we don't have, and we also have oral sodomy. So we have all kinds of things going on there where the condom doesn't answer the question.
True. Again, it's a consideration. It's not the end all be all. It's a consideration. It's testimony that was introduced. There's also information that the last assault, I believe the last rape, which I think that was testimony that those occurred in her room, had been 2 weeks since that last assault had occurred prior to the collecting of those sheets. And then the collecting of the sheets in defendant's bedroom, we don't have a time period, but I believe there was information that that was some period, possibly even longer than 2 weeks. But we have this 2-week period where nothing has happened. And I think that has to be taken in consideration as well.
Well, under subsection F, once we have the testing, if it's unfavorable to the defendant, something happens. If it's favorable to the defendant, something happens. And if it's not definitive, something happens. And that's the point at which the district judge looks at the evidence in relation to the whole case and makes a determination of where we go.
Of where you go, yes.
But that's after we have the testing. And it appears to me that the state is trying to argue the second step as precluding the testing. But the testing is basically, if it has the potential of providing exculpatory, you do the testing. And then you look at how it fits into the overall scheme.
But as a part of that, I believe, and you might have said this, but the district court under the statute still has to make that determination of whether the testing may produce non-cumulative exculpatory evidence relevant to the defendant's claim that he was wrongfully convicted. And here the question is, what would this evidence produce? What exculpatory evidence would this produce? And I don't believe, the state doesn't believe that the absence of defendant's DNA would tend to prove or disprove any of the facts at issue regarding his guilt or innocence.
So you dispute that if the state had tested those materials and the report of DNA testing indicated that there was biological material on the sheets, on the comforter, whatever, but not the defendant's, that report would not be exculpatory evidence that you would have to turn over to defense?
Are you talking about prior to trial?
Right.
I believe that's different.
Well, my question is, would that be exculpatory evidence for purposes of Brady obligation to turn over favorable evidence to the defense. That the defendant's DNA was not found on the sheets upon which the victim claimed the act occurred.
The Court of Appeals looked at this, and I would have to agree that I don't know that the absence of his DNA would tend to prove or disprove any fact that was a material issue. So looking at it that way, I don't know that the absence of his DNA would necessarily be exculpatory. Now, in most instances, would the state probably turn it over? I believe they would.
Let's take it from there. If the state had turned it over, under what circumstances can you contemplate that the defendant would not attempt to introduce that evidence at trial? Right now, thinking about it, I can't think of, I think that they would probably attempt to introduce that. Because it's relevant to his defense?
If possibly, yes.
And would that therefore be exculpatory?
It could be. And I believe at that point and at this point, I think you kind of have to look at it differently. But I think now looking at, again, the whole picture, everything that was produced, all the evidence that that was in front of the jury, and I think that's what the district court looked at, and they, as well as the Court of Appeals, determined that it would not produce exculpatory evidence. Testing whether there be absence or whether there be DNA. Obviously, if there is DNA, defendant's DNA, that's going to be detrimental. And he doesn't just ask for testing for his DNA. He asks testing for his DNA, the victim's DNA, and his wife's DNA.
In light of what you just said, that the presence of the defendant's DNA on any of these items would be detrimental, and I understand you have a conviction, but what's the harm in this? And why wouldn't you be almost joining that motion?
I'd say that there's not a harm, but again, the way the statute is written, I believe that the state is essentially, and honestly, we don't have, and I think this was in my brief below, the state does not have a problem testing if the court, and that was argued, I believe, to the district court, if it determines that that this is possible, that exculpatory evidence could be found.
Or inculpatory. I mean, it goes both ways, and it's not necessarily exculpatory if it's not there.
Right.
It could be argued that way.
Right. Yeah. But I believe the state, it has to be looked at as we are a steward of the resources. And so the district court does have to look at these thresholds put into the statute and make that determination after reviewing all of the evidence before it. And I believe for that reason, it is our position and it is our job to look at what there is as well and argue whether or not there would be, whether it would be reasonable that the testing may produce non-cumulative exculpatory evidence. And as I said, if this court determines, first of all, and I guess I didn't even get to start with this, but first of all, if you determine that the district court did not even go through the proper analysis, because I believe that has been argued, that they were looking at it more as no DNA produced, no DNA evidence produced, therefore no testing. If you determine that the district court got that analysis wrong, then this should be remanded for a hearing on the statute and a determination, basically going back from the beginning, a determination of whether the testing may produce non-cumulative exculpatory evidence. Now, if you determine,
Didn't the Court of Appeals make that determination that there was no fact that would be proved or disproved by the DNA testing?
yes,
So we would have to overrule the Court of Appeals in order to send it back to the
Yes.
district court, would
Yes.
we not?
and I probably wasn't clear on that, but yes, these go hand in hand.
And our standard of review for that?
I believe the standard of review here is a question of law, which you have unlimited review over. I believe that's what I cited in my brief. That the summary denial of a request for DNA presents a question of law.
And that question of law is set up as the best case scenario for the defendant is that his DNA isn't there. That's the best case scenario, because if his DNA is there, then he's got some more explaining to do.
Right.
So the best case scenario is that his DNA is not there, and if that's the best case scenario as a matter of law, would that qualify as exculpatory? And the district court and the Court of Appeals just jumped to that point and answered that question, and that's really what we're looking at. Isn't that the bottom line here?
Doesn't the best case also include that someone else's unidentified person's DNA is there?
I don't see how, I guess I don't see that, because you could have a bunch of DNA in there. It still doesn't change the fact about what her allegation is as to him. But
I believe the issue would be more about his DNA, not some unidentified DNA. I kind of think that's a red herring.
Didn't she say that she had a boyfriend that they had relations with, and if the boyfriend's DNA was on the sheets, that would indicate that relations leaves material, and if there's not the defendants, then he wasn't doing the same thing the boyfriend was doing? That's the argument, that we're not talking about exonerating, we're talking about being favorable evidence for the defense.
Well, first of all, yes, there's testimony about a boyfriend and relations, but I don't recall there being testimony, and again, it's been a long time, you are in a better position than I am, but I don't recall there being testimony that those relations took place in her bed. So I think you have to know that first, and there might be testimony. And because of that, I don't see unidentified someone else's DNA or biological material being exculpatory. I think it's more likely, obviously, that the question is his DNA, not the victim's, not his wife, of which he also asked for. I think the question is more about him.
Can't you see defense counsel arguing to the jury, if this really happened, the way the victim says it happened, why wasn't my client's DNA on the bed sheets? Can you see that argument being made?
Yes, that's a
Would
reasonable
that be an
argument.
appropriate argument to make?
Sure.
And if you can argue that fact, when arguing for a not guilty verdict, why isn't that an exculpatory fact? That's what I'm having trouble with.
Again, it could be, but our position and the district court's finding was that based on all of the evidence, testimony, what was presented at trial, the case as a whole, that this testing would not produce non-cumulative exculpatory evidence.
Is your argument that that would be cumulative evidence?
No, I'm simply citing the statute. The statute refers to non-cumulative evidence. Obviously, if you're looking at biological material, it's not going to be cumulative, because I don't believe there was any biological material introduced at trial. But that is the verbiage of the statute.
If you're going to do that, weigh this potential evidence against the totality up front in deciding whether to order testing, what's the purpose of subsection F? In LACA, we said the court may well be called upon to weigh the evidence to make a probabilistic determination about what reasonable, properly instructed jurors would do with the new evidence in light of the totality of the circumstances. But the statute does not contemplate that exercise of discretion in determining whether to order the testing in the first instance. And what I hear you arguing is you're arguing the totality of the circumstances, overwhelming evidence with respect to that first part of the statute on ordering testing.
Well, I think I am arguing that the district court does need to look at the record before it, which would be the testimony and the evidence at the jury trial. And I believe that's also the way that the Court of Appeals reviewed this, because they stated that a review of the record here conclusively shows that the requested testing could not produce exculpatory evidence. So I think that does have to be a consideration upon making a determination, because if the district court doesn't make a threshold determination as set out in the statute, then I would see it being, if you make the request for testing and there's biological material that was collected, if there's no determination made on the record of the information you have in the record, then I think it's just carte blanche, you get testing. And the way the statute reads to me, I believe there is, it states that the court needs to make a determination. And so if they didn't consider the record, the trial record, I'm not sure what they'd be making that determination with.
Well, look at Smith. Smith had an admission of intercourse, but the allegation that it was consensual.
Mm-hmm.
So there was no relevancy of the biological material
Right.
to the issue in the case.
Right.
So in that case, there would need to be a determination of whether it was exculpatory with respect to the issues that were presented to the jury.
True, but I don't think it's a case-by-case determination. I mean, I think this is something that the district court needs to make that determination in each case. I don't think that just because in that case, based on those facts, the determination is made, but in this case, the facts are different, so there's no determination made. You just carte blanche get testing. I don't think that's what the statute contemplates. And that may be confusing, but I still think that the district court has to make a threshold determination. Otherwise, I believe it'd be testing, you just get testing if you file the petition. And I see that I'm out of time.
You are, but I just have one maybe, and it's not our position here at this court to second guess how prosecutors prepare their cases and what evidence they choose to bring. But I'm just curious as to, in these cases, at least from my experience with these cases, is that whatever kind of corroboration you can get, especially when it's a he said, she said kind of situation, is what you rely on. And this would have produced potentially very inculpatory kind of evidence. Why wasn't, and it was gathered in a manner that anticipated that type of DNA testing. Why wasn't it done? Do you know?
I can't answer that.
Okay.
I wish I could, but I can't. But you're right. It would be, it would have been a good idea, but it wasn't.
I understand your position,
Right.
but it just seems strange.
So yeah, I can't answer that.
Any more questions? Any further presentation?
No, we would simply ask that the district court and the Court of Appeals be affirmed.
Thank you, counsel.
Your Honor, unless the court has further questions, I'll just stand with the arguments already presented.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.